guys, it's Kathy. I hope you're doing well. It's Wednesday night. We made it to Wednesday night. So we have a bond hearing for a felon who apparently attacked a defense lawyer in the hallway of a courthouse. Now, we don't have video footage. We're not here to watch the attack. We're here to watch the bond hearing and find out what happened. Because assault cases judges don't like, but assault cases against court officials don't. I mean, they're not staff of the court, lawyers are, but they're damn close. They're close enough to really, really tick off judges. So let's see what this judge does. We are in Colorado. We are in, I'll tell you where we are as soon as I remember. Starts with an A, Alamosa, I think, Colorado.
And then what do you do from that point?
We moved over outside of Division 302. I had him take a seat on the bench. He stated to me that there was a gentleman wearing a blue shirt and a tie that had seen the whole incident and asked me to speak to him. At that point, I had another deputy take my position and stand by with Mr. Ashby while I went and spoke to the potential witness.
Okay, and we're going to get to that individual here in a moment. I want to take a step back. Was it your understanding that there was another court case being heard around this same time that involved the individuals we're talking about?
I learned that through the investigation, yes, sir.
Okay, and without getting into great detail there, did you come to understand what Mr. Steinberg's role was in relation to that other case?
Yes, sir.
And what was that?
He was defending the defendant who was being charged with a crime against Mr. Ashby's nephew.
And so was it your understanding that there were family members kind of on both sides of that case who were in the public area when this occurred?
Yes, sir.
Okay. This individual in the blue suit that the defendant directed you to, was it your understanding that he was affiliated with either of those two families?
He was not affiliated with either family side.
Okay, we're going to get back to him in just a second. As you were escorting this defendant, Mr. Ashby, off to kind of the other hallway away from everybody else, did you come into contact with anybody else that provided you information about what may or may not have just occurred?
As we were walking, there was another female that I was not able to identify that stated that the attorney should be arrested. I asked her if she would be willing to do a written statement. She said no. I asked her if she would be willing to verbally tell me what happened. She again said no and entered the 302 courtroom.
And so did you attempt to get any additional information from this other potential eyewitness at that point?
By the time I asked another deputy to go in, we could not locate anyone matching her description in Division 302 where she had gone.
Okay, so it sounds like that whoever this woman was, whatever she may have seen, we weren't able to follow up on that.
Yes, sir.
Okay, so I'll take you back to the gentleman in blue, the defendant directed you to.
Yes, sir.
Were you able to follow up with that individual?
Yes, sir.
And was that individual willing to identify himself and provide a statement?
Yes, sir.
And in general, without getting into details, what did he tell you about what occurred?
He stated that Mr. Ashby had approached Mr. Steinberg aggressively, that Mr. Steinberg had told him to go back into the courtroom. He should not be in that area, that Mr. Steinberg was at one point aggressive towards Mr. Ashby, trying to create space between them, and then Mr. Ashby had taken Mr. Steinberg to the ground.
So then is your understanding that either yourself or other members of the Arapahoe County Sheriff's Office contacted other individuals who had witnessed the altercation?
Yes, sir.
And did you obtain statements from those individuals as well?
Yes, sir.
And after reviewing the information provided and kind of the totality of the information provided to you, did you determine whether or not to take the defendant into custody?
Yes, sir. It was determined that Mr. Ashby was the initial aggressor.
And after you took him into custody, actually, let me back up. During the course of taking him into custody and the moments thereafter, did Mr. Ashby make statements to you?
He did make spontaneous utterances.
And after he was taken into custody, did you actually?
Okay, this is the officer that handcuffed him and took him away. Every single next person that comes on the stand adds a little bit more crazy to this story, guys.
Provide him with a Miranda advisement.
Yes, sir.
And what was the substance of that advisement?
I read it directly from the Miranda card that Arapahoe County Sheriff's Office provides to all of us.
After being advised of his rights, did the defendant agree to waive those rights and speak to you?
Yes.
Not Alamosa. I was wrong. It's Arapahoe.
Sir.
And what did he tell you about what occurred?
Mr. Ashby stated that he had approached Mr. Steinberg and his client. He wanted to see the child killer, that Mr. Steinberg had pushed him after telling him to get back into the courtroom. He stated that Mr. Steinberg pushed him 3 times, at which time he took him to the ground.
Now, you mentioned a particular phrase there, child killer or child murderer. Was that your kind of summary of what the defendant was saying, or is that what he told? Is that the words that he indicated that he used?
To the best of my recollection, that is the words that he used.
And is that how he was referring to Mr. Steinberg's client as he was approaching?
Yes, sir.
And after speaking to the defendant, let me back up. Did Mr. Ashby indicate who approached whom when this altercation occurred?
I don't recall.
So let me ask you a better question. Based on what the defendant told you, who approached whom?
Mr. Ashby approached the client of Mr. Steinberg.
And when he approached, how did the defendant describe Mr. Steinberg as getting involved?
He stated that Mr. Steinberg had stepped in between. They were in a group speaking, had stepped in between him and told him to get back into the courtroom and tried to, I guess, convince him to leave the area.
And it was after the defendant approached Mr. Steinberg and his client that things turned physical. Is that right?
Yes, sir.
Now, to be fair, did he indicate who put hands on whom first?
Are you referring to Mr. Ashby?
Yes.
He stated that Mr. Steinberg pushed him 3 times.
And then what did Mr. Ashby admit to doing as a result thereof?
He took him to the ground.
And let's be more specific about that. What specifically did he say about his actions?
I don't remember his exact verbiage. I'm sorry.
I guess I just want to make sure we understand what took him to the ground means. What did you take that to mean?
I took that as what I understand to be a double leg takedown and drove him into the ground.
Would that be consistent with how you found Mr. Steinberg when you came out into the hallway?
Yes, sir.
So then, based on kind of the totality of all this, your understanding of what information was collected from eyewitnesses and what information you collect from the defendant, was there a general agreement about the order of operations here?
Yes, sir.
One moment.
Judge is eating in court. No eating in court, Judge.
All I have at this time, Frank.
Thank you. Any cross-examination?
Yes, thank you.
I do have to apologize before this lawyer gets up to all the people who watched the OJ trial with me and finished, because this is going to give you PTSD when this guy starts asking stupid questions. This is not OJ. Just pull yourself out of that PTSD. You'll be fine.
Good afternoon, Deputy.
Good afternoon, sir.
So I want to pick up from the start with the start here. You were in the courtroom and you were called to come out into the hallway, right?
I was notified in the back hallway and cut through the courtroom.
And you turned your body-worn camera on as you entered the courtroom. Is that correct?
Yes, sir.
Okay. And as you exited the courtroom into the hallway, you looked to your left and saw Mr. Steinberg on the ground, right?
Yes, sir.
And to the right, you saw Mr. Ashby.
Yes, sir.
He was standing there trying to tell you what happened, right?
His family member started to speak to me. I asked them if I could remove him. I placed him into handcuffs, detaining him, separated him so I could speak to Mr. Ashby further.
You made no attempts to resist or flee, correct?
No, sir.
And as you moved him kind of down the hallway, that's when you heard from that first witness, right?
Yes, sir.
And from everything you could tell, that witness wasn't on either side of this argument, right? Or of this court hearing that was going on.
As far as I can tell.
She actually went to a different courtroom.
Yes, sir.
But she spoke as though she saw what happened, right?
Yes, sir.
And she said that the attorney needed to be placed in handcuffs, right?
Yes, sir.
Did you take that to mean that, in her opinion, the attorney was the one that should be at fault for this incident?
Objection, Your Honor. 602-401.
Any response as to personal knowledge? Speculation?
I think that it's within an officer's expertise to make judgments based like these ones.
All right, with respect to the 401 objection, the court will note that hearsay is permitted during a preliminary hearing. People may rely on it in bulk. They just can't rely on it entirely. And so the court will permit hearsay during this hearing. With respect to the personal knowledge piece of this, I'll permit Deputy Tucker to answer the question if he knows the answer. Deputy Tucker, if you don't know what this individual intended to communicate, then you're welcome to say that as well. So I'll overrule the objection. You may proceed.
Can you repeat that? I apologize.
Just based on what this lady said, and she was, just to be clear, she was described as a lady in brown or lady in black, right?
Yes.
Based on what she said, would you take it that she was thinking that the attorney was kind of the one at fault for this incident?
So this lawyer is trying to stretch as far as he can, and it drives me crazy. But you know what else is more crazy? This lady was described as the lady in brown or the lady in black, right? Every single one of us has a clear picture of this lady in their heads, and they're all different. So we are all thinking of a completely different lady when we hear just that. She's the lady in brown. We all can picture that, and they're all different. Some of us have blonde hair, some of us have brown hair, some of us have, she's wearing, a red skirt, a blue skirt, some of us tall, thin, fat, skinny. I just think it's funny because they all know who they're talking about this whole time. But this lawyer is saying, she said the words, the defense attorney should be locked up, which, maybe we're going to hear more about that. But he stretches it. He's very annoying.
I took it as the beginning of my investigation, and I took it as that was her opinion and tried, I should say, to get more information from her.
Right. Certainly you don't just believe one person, but that was her opinion.
That was her opinion.
And at this point, it was approaching 1:30, right?
Correct.
And it's pretty common, just I'm sure, in your experience, for court to start at 1:30
Yes, sir.
In this courthouse. And she went into a courtroom at that time, right?
Yes, sir.
So it's certainly a possibility that she maybe needed to be in that courtroom for a court case that she was either a defendant in or a witness of.
I would have no idea. She could have been here to support someone.
Right. But there's certainly a possibility that hearing could start at 1:30.
Absolutely.
Mr. Ashby was asking you to, and other deputies to follow up with her, right?
Yes,
And at one point, someone finally agreed to do that, right?
correct.
Do you know how long it was until someone did that?
I'm not sure, sir.
So as officers and deputies continued their investigations, they started asking around if other people had seen this incident, right?
As far as I know, yes.
And there was kind of, the reports laid out six witnesses, right? Kind of numbered 1 through 6.
I did not collect the witness statements.
Okay. Would it, I guess, make sense to you that there was 4 witnesses or a number of witnesses that were members of the defendant that Mr. Steinberg was representing and family members kind of that were around them in the hallway?
I learned that there were multiple written statements completed. I don't know their relation to anyone.
Okay. But it sounds right that there would have been some written statements by people kind of on the side of Mr. Steinberg's client.
It's possible.
And then there was some written statements on behalf of people who weren't really involved.
The one person I spoke to was independently involved.
So
Guys, it's saying that you guys can't hear anything. It looks like it's fine though, but YouTube is giving me this big message, and I just lost a whole bunch of people. We just lost like 1/5 of our stream. Can you guys still hear anything? It seriously looks fine to me. I don't understand why I'm getting error messages. I'm gonna press play. Let me know if you guys are having problems.
would you agree with me that kind of tensions were high during this careless driving resulting in death case?
I couldn't answer that. This was my first interaction with anyone.
Okay. From just seeing kind of, you saw members on one side wearing shirts kind of in memory of, or
Yes, sir.
something to that extent. So kind of putting the pieces together here, it seemed as though there was kind of 2 sides here, maybe some tension going on.
There's 2 sides, but I did not see anything that would lead to me believing others had tension.
Okay. And would you agree with me that it's fair to say that the people that Mr. Steinberg was representing or their family members might have bias in terms of what happened here?
I don't know how to answer that. I didn't speak to them.
You would agree with me that maybe they aren't neutral parties as the individual you spoke with was?
Objection, Your Honor, 602.
Response?
I mean, I believe if he has the knowledge and the expertise to answer that, he should be allowed to.
All right, Deputy Tucker, if you know whether or not these individuals are or are not biased, you're welcome to ask the question. If you don't know, you shouldn't speculate. So I will overrule the objection. I'll permit you to answer however you deem appropriate based on that.
I wouldn't feel comfortable describing how someone would feel without ever speaking to them.
I guess my question is more about a situation like this. Would you agree with me
Good
that
job, Bill. Good job.
there could be biases if you're on the side of, if your attorney is the person that is on one side of things here? If your attorney is a victim in a case, would you agree that you could be biased?
Renew my objection, Your Honor, to 602. I think this is speculative. It also calls into question why any of this is relevant under 401 in the first place.
All right, also stating the objection based on Deputy Tucker's last response. I'll ask you to move on.
Right. So I want to move on to kind of what initially happened here. And we'll come back to some of the witnesses later. So kind of from speaking with everyone there, it was clear that Mr. Steinberg was out in the hallway speaking with his client and some others.
Yes, sir.
And Mr. Ashby was, with his family, was in the courtroom, along with kind of the victim side in that careless driving resulting in death case. Is that your understanding?
Yes,
And Mr. Ashby came out of the courtroom and started saying something to the effect of, "I'm here to see the baby killer," or I'm sorry, child killer or child murderer.
correct.
So I want to talk about those initial words. Would you agree with me that those words, "I'm here to see the child killer," are not threatening in themselves?
No, I would not agree.
Would you agree that they're not threats of present or future physical violence?
Not necessarily. That's a statement of provocation.
Okay. So kind of from a layperson's view here, coming into the hallway, calling someone who otherwise they're just minding their business a child killer, you would describe that as provocation.
You would expect a reaction.
And from a layperson's view, a person just standing there saying those words, would you say it'd be fair to describe them as the provoker?
Just verbally? No, but you have to look at the totality of circumstances.
Right. So didn't you just tell me that just saying those words coming out there was provocation?
That doesn't mean that you're an aggressor yet. That just means you're looking for a reaction.
From a layperson's view, would you agree with me that just saying those words could certainly someone could describe someone saying those words as a provoker?
It's a provocation
As an aggravator?
to try to get the other person to react.
Even if it's just words?
Correct.
And as an aggressor?
It's not a threat at that point. It's a provocation.
So those words in themselves are not threatening. You would agree with me on that?
Correct.
Okay. So next I want to talk about what happened after those initial words, but before any physical altercation. So Mr. Ashby said essentially that told the deputies that Mr. Steinberg came up into his space before any physical altercation.
I remember him stating that Mr. Steinberg pushed him 3 times.
Mm-hmm. But Mr. Ashby was clear that he wasn't there to get in someone's face or cause a fight. He told you that he was just there standing and Mr. Steinberg came up to him.
According to Mr. Ashby, absolutely.
Yes. And Mr. Steinberg said something different, right?
He did.
He said that he got between his client and Mr. Ashby.
Correct.
So no matter what side you believe here, it's undisputed that Mr. Steinberg moved closer to Mr. Ashby. Is that correct?
Not necessarily. You can move horizontally to block someone's path, not necessarily moving towards them.
Was it your understanding from talking to Mr. Steinberg that he moved horizontally or that he kind of moved up closer
That
to
he
Mr.
moved
Ashby?
that he moved to block Mr. Ashby from his client.
Would you agree that in doing that, he reduced the physical distance between Mr. Ashby and the side consisting of Mr. Steinberg and his clients and the other individuals there?
It depends on if he moved horizontally and Mr. Ashby continued to move forward. I can't really answer that.
When you generally hear someone say, when I got between someone, generally that would mean that that person got closer to Mr. Ashby in this situation, right?
Not necessarily.
Okay. I want to move on to kind of the actual physical force used here. Mr. Ashby was very clear about what he said happened, right?
Yes, sir.
He said it over and over, right?
Yes, sir.
A a few times without being directly asked, and then again in a Mirandized interview.
Correct.
He said that Mr. Steinberg shoved him 3 times before he took any actions, right?
Yes, sir.
He even demonstrated it with his arms going 1, 2, 3. Isn't that right?
Yes, sir.
And when Mr. Steinberg was asked what happened, he also admitted he pushed Mr. Ashby first.
He stated that he pushed him to create space. Yes, sir.
And in fairness, he said he did so to protect his client, right?
Yes, sir.
But what's not in dispute is that Mr. Steinberg was the first to use physical force in this dispute, right?
Yes, sir.
What's not in dispute is that Mr. Steinberg was the one that turned this verbal altercation into a physical one.
He was the first one to push.
I want to talk about the sizes of the 2 individuals here. Because when disputes kind of turn physical and self-defense is being claimed, one thing that's often looked at is the size and weight of each individual, right?
Okay.
Is that fair to say?
Can be,
Size
yeah.
doesn't matter.
And in this case, Mr. Steinberg was significantly taller and heavier than Mr. Ashby. Isn't that right? And in looking at the NCICs for each individual, are you familiar with those?
Yes, but I have not viewed them.
Okay. Those generally contain some driver's license information,
Yes, sir.
and those would contain people's weights and their heights.
Yes, sir.
For Mr. Ashby's driver's license information from the NCIC, would you agree his height was 5'10", his weight was 180 pounds?
I haven't reviewed it, sir.
And Your Honor, if I may approach the witness.
You may.
I'm going to show you what's been marked.
Dude, we're here because a lawyer just got violently attacked and you want to approach the witness? Okay, this witness isn't the one that violently attacked anyone, but still.
Discovery page 102. Do you recognize that?
I don't recognize it, but I know what it is.
Can you tell me what it is?
It's the Colorado driver license dossier.
For Mr. Ashby.
Yes, sir. Sorry.
And are you able to see his height and his weight?
Yes, sir. 5'10", 180 pounds.
And would his NCIC have the same information?
It would have the same information.
And I'm going to show you what's been marked. What's discovery page 268 and 269. Split between 2 here, but you're able to see that.
Yes, sir.
And is this Mr. Steinberg's driver's license information?
Yes, sir.
And are you able to see his height and his weight?
Yes, sir.
What are those?
6'1", 245 pounds.
Okay. All right. We're about to find out in a few minutes how just wrong that both of these questions were. So the defendant apparently is shorter and weighs less by 30 pounds and 3 inches. So he's 3 inches shorter and he's 30 pounds smaller than the lawyer. So, but wait, just hold on, okay? Hi, Kristen.
So based on those, you would agree with me that Mr. Steinberg is significantly heavier and taller than Mr. Ashby.
Yes, sir.
Would you agree with me that a certain degree of reasonable force or a certain degree of force may be reasonable in this situation when one is outmatched in size and weight that might not otherwise be reasonable?
Your Honor, I'm going to object at this point. I recognize, as I indicated earlier, that the defense feels that this is a self-defense case. I think that some latitude, even at this stage, is reasonable. That's why I brought it up. But I think at a certain point, we are extending the scope and the purpose of the hearing.
Any response?
I know that courts in Colorado sometimes are willing to look at affirmative defenses at this stage. Mr. Ashby does have a constitutional right to self-defense. We do believe that it should at least be considered to some degree. And and we would ask the court to allow this questioning.
All right, the court will note that at a preliminary hearing, affirmative defenses are not relevant. They're not relevant to the issue of probable cause. The court will cite People v. Adams County Court, 767 Pacific 2nd, 802. That's a Colorado Court of Appeals case from 1988 that provides the same. The court does believe that some degree of latitude is appropriate at a preliminary hearing, but if we're going to walk through the elements of potential defense of self-claim, things along the lines of initial aggressor or reasonable use of force, then we're getting a little bit close to an irrelevant issue. So I'll sustain the objection. I'll give you some latitude as it pertains to these questions, but let's stay away from the affirmative defense, please.
Understood, Your Honor. Kind of moving on to the actual force used by Mr. Ashby. It was repeatedly referred to as a body slam, right?
Body slam or a takedown.
Okay. But when Mr. Ashby was asked, he just said he took out Mr. Steinberg's legs, right?
Yes, sir.
He swooped them or scooped them?
Yes, sir.
And when individuals that were with Mr. Steinberg, like his client and the individuals there, they described it as simply kind of Mr. Ashby taking Mr. Steinberg to the ground, not that they lifted him up or anything like that.
I don't remember speaking to them, so I'm not sure what they said.
In terms of kind of after the takedown, witnesses said that Mr. Ashby was kind of still heated after this, right?
Yes, sir.
That he was saying something to the effect of, "You started this."
That's what I heard as I was coming out of the courtroom.
That maybe he was like clapping his hands or making noises.
That I'm not aware of.
Okay. But what's clear and not disputed is that Mr. Ashby didn't continue any further physical altercation once Mr. Steinberg was on the ground.
Not as far as I know.
There was no, as far as you know, there was no allegations of that.
That's
Correct.
half right. That's a partial truth.
So when police arrived, Mr. Steinberg was still on the ground, right?
Yes, sir.
He was pretty clearly in significant pain, looked to have a significant injury even before he was seen at the hospital, right?
I believe he had told me at one point that he had a back injury.
Did you remember him telling you that he had pre-existing back issues?
That's what I meant. I apologize.
Okay.
Can I ask you to clarify that? You said that that's what you intended to say?
Yes, sir.
Okay, thank you.
So as such, it's likely that he was particularly susceptible to the type of injuries he received.
Objection, Your Honor, 602-401.
Response?
I think it's relevant here. I think that if the officer has the knowledge to answer it, he certainly can. I think that this is somewhat common knowledge, or at least doesn't necessarily require expert testimony. So we asked the officer to answer it if he's able to.
All right, with respect to the hearsay objection, the court will overrule that on the same basis the court previously overruled the hearsay objection. With respect to the personal knowledge / speculation piece of it, obviously, Deputy Tucker, if you know about the answer to the question in terms of whether the existing injury may have been exacerbated, you're welcome to answer that question. But again, you should not speculate. And so if you know the answer, you're welcome to answer it. I'll overrule the objection. You may proceed.
Your Honor, I apologize. The objection wasn't for hearsay, it's for relevance, that this is entirely irrelevant.
So why didn't you say that, sir? Why did you just shout numbers out? Why didn't you say objection relevance? Why can't you just do that? Now, luckily, this judge knows the law. This judge seriously knows the law. I mean, you know how a lot of judges, when a lawyer objects, the judge is like, give me a case. This judge already knows all the cases.
And to the extent that the victim may or may not have had any sort of pre-existing conditions, just doesn't move the ball here at this stage in any way, shape, or form.
All right. One of the things that the people do need to prove is causing serious bodily injury. And so the court will find that the cause of the injury is at baseline relevance. with respect to a potential prior condition and the fact that that was aggravated by this incident. Ultimately, throughout the law, the aggressor takes the victim as they find the victim. And so if he already had an injury that was exacerbated, then I don't think that changes the calculus. But ultimately, I'll let you explore the cause of the injury further. And so I'll overrule the objection as far as that goes.
Thanks. Sorry, that was a lot. Can you repeat that?
I can. So kind of given his pre-existing back issues or injuries that Mr. Steinberg had, it's likely he was particularly susceptible to the type of injury he received here, right?
It would depend on how long ago that injury was. I didn't go into that much detail with him.
We certainly can't rule out that the level of force here would not be enough to cause that type of injury just to a healthy individual.
I could not.
That calls for expert opinion under 702.
I'll sustain that objection.
Does it? Okay, let's pretend that that wasn't overruled. If someone were to leg sweep and body slam you on the ground in the hallway of a courthouse, and you have multiple hip fractures and a spine fracture, would a normal person sustain those types of injuries from that event? And I don't know what I mean by normal person. Woman, man, I don't know what I mean, but if a normal person, and you're going to find out why the lawyer's not normal, not what we consider a normal person in a few minutes, but if you were just a normal person and that he leg sweeped and body slammed you onto a hard floor in a courthouse hallway, would you break multiple fractures to your hips and spine? Is that stretching it?
So I want to move on to there was two witnesses that were mentioned as being that were brought up in the report that didn't appear to have a connection with the client Mr. Steinberg was representing or that family.
Okay.
Does that sound right?
Yes.
One of those individuals was interviewed, but suggested that he didn't see Mr. Steinberg push first. Does that sound right?
Correct.
And it's undisputed here that Mr. Steinberg did push first, right?
According to the other witness that I spoke to, yes.
And Mr. Steinberg himself.
Yeah.
Right. So that it'd be fair to say that witness maybe didn't get the best view or didn't have the best memory of what happened.
Or wasn't looking, I don't know. But he wasn't able to say one way or the other.
And then there was the witness that a sixth witness, which I believe was the one we were talking about earlier, with the tie. Is that correct?
Blue shirt and the tie, yes, sir.
That witness, he said that Mr. Steinberg was being aggressive, right?
He stated that they were both being aggressive.
You asked that witness, did Mr. Steinberg just push Mr. Ashby? Well, do you remember asking that witness why Mr. Steinberg pushed Mr. Ashby?
Yes.
You remember what he said?
Not verbatim. I believe it was something to the effect of to create space.
Do you remember leading the witness by saying, did Mr. Steinberg just push to create space?
I asked a question, sir.
Do you remember that witness replying to that question by not saying yes, but instead saying that Mr. Steinberg was also aggressive?
So that lawyer just asked a weird question to a cop. He said, do you remember leading the witness and asking if he pushed just to create space? So when a police is interviewing people at a scene, are they allowed to lead? Or can responses be thrown out of court if a police officer leads the witness? If a police officer says, did he push him just to create space? That is a leading question. You can't say that in a court, right? You can say, why did the lawyer push this guy? But you can't say, did the lawyer push this guy to create space? Okay, leading question. But can cops ask leading questions when they're interviewing witnesses at a scene? And if they do, is that thrown out of court? Does that work like that?
As I stated before, he did state that they were both aggressive.
But he would not agree with you that he was just pushing to create space, right?
I don't agree with that.
The interaction you had with the gentleman in the blue shirt was captured on your body-worn camera, right?
Correct.
And if I may approach the witness, Your Honor.
You may.
Sorry, 129:44.
And Your Honor, I'm going to object to impeachment here. I just think we're getting, again, quite far afield of our purposes here. And this is all designed to really try to buttress the self-defense case, which we've already established is really outside the scope of this particular hearing.
Counsel, what do you intend to impeach with? Is it body-worn camera footage?
It is of the individual in the blue shirt and tie. It's 1 minute and 11 seconds. Mr. Tucker interviewing the individual. All right, I'll just stop here.
The judge just asked a simple question. What are you trying to impeach? And the lawyer just gave a circular answer that meant absolutely nothing.
Deputy.
Does this pertain to an initial aggressor issue?
Your Honor, it pertains to kind of exactly what transpired here.
That's not an answer. That's not an answer.
I do think that to some degree there's aspects that overlap with initial aggressor and who did what and what timing.
All right. Well, the court will find that in terms of the allegation that Mr. Ashby took Mr. Steinberg down, how that happened and how it resulted in injury, obviously all of that is going to be relevant to the elements of the offense. To the extent that we're just exploring Mr. Steinberg pushing Mr. Ashby first, the purpose of pushing Mr. Ashby first, or even how hard Mr. Ashby was pushed first, all of this goes to the affirmative defense. And so if you are impeaching in order to establish facts related to the takedown itself, then I'll permit you to do so. But if it goes to the initial aggressor issue, the court will sustain the objection.
He just confused the lawyer. The lawyer's dumbstruck.
Your Honor, I think that there's some aspect of both here with this. It's an individual's kind of recollection of what he saw happening here. I think we've heard from we've heard from witnesses already about what happened here, so I think it'd be appropriate. And we also heard some information about this witness in direct examination. So I think it only makes sense that we more fully explore what this witness actually said.
Does this pertain to the pushing and the circumstances under which the pushing occurred?
I would say it does.
All right. The court will find that that's not relevant. I'll sustain the objection. I'll ask you to move on.
Okay.
Don't worry, he can't let it go. He's going to keep going back.
So if we look at the unbiased eyewitnesses, and I'll define that myself, the witnesses that didn't have an involvement with either side of this case, right? Is it fair we use that term we use that for this hearing right now? So if we use unbiased to mean that, we have 3 individuals, right?
I'm only aware of 2.
We have the individual who said that he didn't see the initial first push. He didn't see that Mr. Steinberg pushed first.
Correct.
And we just talked about that one, how that person might not have the best view. We have the individual in the blue shirt and tie,
Yes, sir.
and that person said that both people were aggressive, right?
Correct.
And we have the unidentified individual, the lady in the brown or black jacket.
That made no statement at all.
She did make a statement to you, right?
She made an opinion. That's not a statement.
She said words to you.
Okay.
I'm asking you.
Yes.
And she told you that we discussed this earlier, that the takeaway of those words was that Mr. Steinberg was the one responsible.
That's not what I said.
What'd you say earlier?
What did I say earlier?
I'm asking.
Was that I was at the beginning of my investigation and it needed to be looked into.
Okay. All right. I have nothing further, Your Honor.
All right. Any redirect examination?
I'm not going to spend a lot of time on the why behind all this, but I do want to follow up on a couple of the things that defense asked you. Defense counsel had you recount the relative size of the victim and the defendant in this case. Remember that?
Yes, sir.
He didn't ask you about their ages.
Correct.
Are you aware of the victim's age at the time of the attack?
Yes, I am.
And how old was he?
69 and approximately 6 months.
And
70.
what was the age of the defendant at the time?
I believe around mid 30s.
Does 36 sound right?
Yes.
Would that make him half or nearly half the age of the defendant or the
Yes, sir.
victim?
That's why lawyers are such slime balls. That other lawyer was like, so he's 30 pounds heavier and 3 inches taller? Oh, he's a bigger guy. He's 70 years old. That's what I mean by not normal. So yeah, 70-year-old getting body slammed is going to break multiple bones. Abso-freaking-lutely. But would a normal person still break bones? That's...
Yes, sir.
Okay. And I know the defense asked you a lot about how things became physical. Was there general agreement in terms of the order of operations here?
Yes, sir.
And does that include what you learned from the defendant?
Yes, sir.
Is there any suggestion that any of this would have happened had the defendant stayed in the courtroom?
No, sir.
Is there any suggestion that any of this would have happened if the defendant did not approach the victim?
No, sir.
One moment. Go ahead. Thank you.
May this witness be excused?
Without that.
Okay.
Any objection from the defense?
No objection.
Now
Thank
we
you, sir.
get
Go ahead.
now we get a little crazy. Now things start to build on each other, and it gets even worse.
Step down. Any further witnesses from the people?
We next call investigator Jamie Oliver. I'm sorry, Jamie Wright.
Good afternoon, Investigator Wright. Before you get seated, I'm going to go ahead and swear you in, if you would, please. Do you swear or affirm under penalty of law that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you. You can have a seat. And I will ask you to adjust that microphone so it's in front of your face. Counsel, whenever you're ready.
Thank you. Good afternoon, ma'am.
Hello.
Can you introduce yourself to the judge? Spell your first and last name for the record.
Yes, it's Jamie Wright, JamieWright.
How are you currently employed, ma'am?
I'm an investigator with the Arapahoe County Sheriff's Office.
What does it mean to be an investigator with that department?
Patrol or the jail or courts will complete offense reports. They'll get sent up to us. We'll do further investigating and then file the charges.
Is akin to what other law enforcement agencies might call a detective.
Correct.
How long have you been in law enforcement?
Almost 25 years.
Do you have any experience with any other agencies other than the ACSO?
No, sir, I don't.
And during your time with the Arapahoe County Sheriffs, what other ranks or assignments have you held?
I started in detentions. I worked in our training division. I've been patrol and most recently investigations.
And how long have you been with the investigations unit?
Since 2018, so 8 years.
How did you become involved in the case that we're here to discuss?
This was what we call a felony in custody. It's someone who's taken in on PC charges. And then I filed the case, so I was assigned the in custody.
So fair to say then that your job is to kind of follow up once the original investigation is completed by the officers that respond.
Correct.
And did you do that?
I did.
How do you go about doing something like that?
I read all of the reports, watch body cam, read witness statements, review any other paperwork that may be associated with the case.
And then do you complete follow-up interviews as well?
I do.
All right, so we're going to talk about all that in turn. First of all, I want to focus on the victim, Mr. Steinberg. Did you follow up with him or with medical service personnel that treated him to determine the extent of his injuries?
Yes, I received his medical records.
And what can you tell us about the extent of those injuries?
He has multiple pelvic fractures that require several surgeries to hopefully fix.
And did yourself or other law enforcement agents request an SBI form from any of the treating medical professionals?
Yes, they did.
And when I say SBI form, what do I mean?
That's a serious bodily injury form that is filled out by a doctor.
And that was filled out in this case?
Yes.
And what did that form indicate?
That he had multiple fractures. If I remember correctly, it said that he might have spinal fractures as well. That was not listed that I could see in the medical records.
Bottom line, did the doctor opine that Mr. Steinberg suffered serious bodily injury results of this incident?
Yes.
All right, so let's talk about how you went about following up the investigation in this case. Did you yourself actually reach out and conduct additional interviews with witnesses or potential witnesses?
Yes, I did.
I want to focus specifically on a couple of those. Did you reach out and conduct a follow-up interview with an individual named Glenn Hansen?
I did.
Matt, what was your understanding of what Mr. Hansen, well, let me back up. Was it your understanding that whether or not Mr. Hansen was actually present and witnessed any portion of the incident?
Yes, I did.
What was your understanding of the purpose that Mr. Hansen was at the courthouse that day?
Mr. Hansen had his own, I believe it was a traffic case that he was here in the hallway waiting for.
And we've already discussed that the case that kind of brought everybody together that day involved a separate, a very traumatic and unfortunate incident. Are you familiar with the other case that I'm discussing?
Yes, I am.
Okay, so what I want to ask you here is Mr. Hansen affiliated with either of the families or the sides in that underlying case?
No, he is not.
Okay, so when you reached out and spoke to Mr. Hansen, what did he tell you about what he observed that day?
He told me that he was standing in the hallway waiting for his case to be called when he saw a gentleman walking very briskly, clapping his hands really loudly, like he was on a mission. He said he was looking for something, and when he found what it was he was looking for, he beelined it for whatever it was he was looking for. He didn't know it. He didn't know.
And what was it about the man that came out of that courtroom that got Mr. Hansen's attention?
The way that he was walking, he called it airborne shuffle. Mr. Hansen was in the Air Force, and he equated it to an airborne shuffle, a very quick pace, not running but not walking.
Purposeful.
I'm sorry?
Purposeful.
Purposeful, yes. Clapping his hands really loudly.
And then what?
Air Force people, is that right? Airborne shuffle? When you walk purposely, not running, but walk very fast towards something?
Did Mr. Hansen describe as his understanding of what occurred next?
So he couldn't see, from where he was standing, he couldn't see the person or whatever it was that the gentleman was looking for. But he could hear a quieter conversation. He couldn't hear what was being said. And then he witnessed the gentleman pick another gentleman up and slam him to the ground.
Now, did it seem to you, or did Mr. Hansen indicate that he was kind of watching this incident the entire time it was occurring, or was his attention divided?
No, he was watching the entire time.
Okay. And did he see, I guess, who was the first person that he saw in terms of actually make physical contact?
The defendant,
And when we're talking about the defendant, who are we talking about here?
Mr. Ashby.
Do you see Mr. Ashby, the person you understand to be the defendant in the courtroom today?
Yes, sir, I do.
Can you point out where that person's sitting and what they're
He's sitting at the defense table in orange.
So I want to shift gears. Are you aware of a statement by an individual, but the name of David Buffington?
Yes,
Did you have an opportunity to reach out and speak to Mr. Buffington as well?
I did.
Now, do you know, and for our purposes here today, do you know what color shirt or tie Mr. Buffington was wearing on the day of the incident?
I believe it was white with a blue tie.
Okay, so he was the individual with the blue tie.
I believe so, yes.
Okay, and what did Mr. Buffington tell you about where he was when the incident occurred?
Do you mind if I look at my report to refresh my
If that would refresh
memory?
you.
Yes.
Yes. With the court's permission?
Of course. Yes, you may rush.
Yeah, that should be fine.
For the record, this is discovery page 111.
Thank you.
Is your recollection refreshed?
Yes.
And before we get any further, Mr. Buffington, the guy in the blue tie, was he affiliated with either side of kind of the underlying case here?
No, he was not.
Appear that he have any dog in this particular fight?
No, he did not.
All right. Where did he indicate that he was when this altercation was taking place?
He was in the foyer.
Okay, and did you get the impression that, well, let me ask you this. Who did you get the impression was closer to the incident when it occurred, Mr. Buffington or the other individual, Mr. Henson?
I believe Mr. Buffington was.
And what did Mr. Buffington tell you and communicate to the other deputies in terms of what he saw occur?
He said that he saw a male in a shirt that said "Justice for," and he didn't know the name of the individual on the shirt, clapping his hands loudly. And he approached a Latino man who I believe to be the defendant in the other case. Mr. Steinberg, sorry, let me back up. He said that the male was yelling something to the effect of, "Let me see the child murder," or the child murder, or something to that effect. Mr. Steinberg stepped in between the Latino male and the other male and told him that he needed to go back into the courtroom. This wasn't the place for him. And then he witnessed the male, Mr. Ashby, pick up Mr. Steinberg and slam him onto the ground.
Did Mr. Buffington observe Mr. Steinberg make contact with the defendant before that occurred?
He didn't believe he did.
You don't recall him saying that he saw?
I think he's, oh, I'm sorry. Do you mind if I review one more time?
Yes.
I'm sorry. Sorry, I am incorrect. He said that he saw the attorney shove Mr. Ashby, and then Mr. Ashby picked him up and slammed him to the ground.
And did Mr. Buffington indicate what it was that that seemed to cause Mr. Steinberg to push the defendant?
Because Mr. Ashby was very aggressive towards the Latino man.
I think I neglected to ask you this previously. I want to go back to Mr. Hansen for a minute. Did he indicate if he got involved in the altercation at any point after the victim was taken down?
Yes, he said that once the attorney was on the ground, he and another individual who he did not know had gone over to the area, and he said that Mr. Ashby was getting ready to drive his elbow into Mr. Steinberg. So he and the other gentleman pulled him off of Mr. Steinberg.
And that again came from Mr. Henson.
That came from Mr. Hansen, yes.
Okay. And so how is it that you understand that these two parties were actually separated?
My understanding is that Mr. Hansen and the unidentified individual who he believed may have been from Mr. Ashby's party pulled him off of Mr. Steinberg.
And so the defendant had to be physically removed from the victim?
Yes.
So Mr. Steinberg, the lawyer, was down on the ground, 70 years old, in obvious pain because his bones were broken. And this guy was about to take an elbow to him. They had to pull him away. Two just bystanders had to pull him away. But wait, there is more.
Did you have an opportunity to also interview the prosecutor that was handling the underlying case in this?
Yes, I did.
And I get why he's so mad, okay? The defense attorney was defending someone who had just killed his 10-year-old nephew. He had just killed his 10-year-old nephew. So, my heart goes out for him. I get why he's angry. I can easily get there. If someone killed my 10-year-old nephew, I probably would also be in handcuffs. I probably would. And we all talk about, how can defense attorneys live with themselves for defending these people? But that's just their job. Their job is to argue the law, not the case behind the law, the law. And this guy wasn't even not even going after the defense attorney, even though he sort of didn't like him either.
And what is that individual's name?
But there's more.
Cole Plummer.
Was Mr. Plummer or District Attorney Plummer present for the altercation itself?
He was not.
Where was he immediately proceeding?
He was in the courtroom getting ready for the hearing that was upcoming on that case.
And did he recall anything of note about the courtroom and who was in there at the time?
Yes, he said that he saw Mr. Ashby get up from the chairs or pews, whatever, relatively, he said with a purpose and exited the doors.
And was there something specific about the defendant that kind of got DA Plummer's attention?
I think it was just the way he stood up and walked out of the room with purpose.
Is the way that DA Plummer described the defendant's movements consistent with the way Mr. Henson described the defendant's movements?
Yes.
Now, were there other witness statements that were gathered from other parties that were present at the time of the assault as well?
Yes, there were.
We're not going to get into all of those. But in total, after reviewing kind of the totality of the circumstances, was there really pretty remarkable agreement in terms of how all of this came together?
Yes, there was.
And was there agreement in terms of which party approached the other
Yes.
and who appeared to be the initial aggressor?
Yes.
And who was it that approached whom?
Mr. Ashby was the person who approached both Mr. Steinberg and the defendant in the other case.
And what was his demeanor whilst he was approaching?
Every witness said it was aggressive, with him clapping his hands really loud and stating he wanted to see the child murder.
Is there anything to suggest that had the defendant not approached, had he not approached in that particular manner, that anything physical would have occurred?
No, there is not.
One moment. All I have. Thank you.
All right, thank you. Any cross-examination?
Yes, thank you. Good afternoon.
Hello.
So I want to kind of go through step by step, starting with the SBI form.
Okay.
You said that you spoke with doctors involved, right?
I didn't speak with doctors, no.
You just reviewed medical records.
Yes.
You don't personally have knowledge of Mr. Steinberg's injuries, correct?
I do not know.
It's only from your review of documents.
Correct.
Moving on to Glenn Hansen. Are you aware that Mr. Steinberg and Mr. Ashby both told deputies that Mr. Steinberg was the first to initiate physical contact?
There were a couple of witnesses that stated that, yes.
But are you aware that Mr. Ashby was one of those individuals?
Mr. Ashby, yes, I am aware that he made that statement.
And Mr. Steinberg did as well?
Yes, he did.
So it's relatively undisputed.
Correct.
And Mr. Hansen said otherwise, that he didn't see Mr. Steinberg shove Mr. Ashby first.
Correct. Mr. Hansen said that from where he was standing, he couldn't see Mr. Steinberg.
When you spoke with Mr. Buffington, Mr. Buffington also called Mr. Steinberg aggressive, right?
They did, yes.
Mr. Buffington said that Mr. Steinberg tried to step between Mr. Ashby and his client, right?
Correct.
Are you aware that Mr. Ashby said many things to deputies regarding this incident?
Yes.
He said things, just kind of, I guess, spontaneous statements or utterances before being questioned, and then also a Mirandized interview, right?
Yes.
What he told officers is that he didn't approach, that he did go outside, that he was yelling, or he got outside the courtroom, that he was yelling, but that it wasn't him that approached Mr. Steinberg or his client, that he kept some space.
He did say that, yes.
And according to Mr. Steinberg, he admitted that he stepped in front of his client to kind of get between them, right?
Yes,
So you would agree with me that Mr. Steinberg admitted that he kind of reduced the physical space between himself and that group and Mr. Ashby?
I don't know that he said those specific words, but he did step in between his client and Mr. Ashby.
So I guess putting the pieces together then, we can surmise that he reduced the physical space between that group, the group of him and his clients, and Mr. Ashby.
Yes.
There was another witness that was described as Lady in Brown or Lady in Black.
Okay.
Familiar with that?
Yes.
That individual made a statement very early on and then didn't provide any further information to police. Is that your understanding?
Correct.
And that statement was something to the extent that the lawyer should be placed in handcuffs.
Something like that. Yes.
Have you made any attempts to identify that individual?
I don't know who she is. I know that they attempted to get her to either give a verbal statement or a written statement or identify herself, and she refused.
Okay. I'm asking you as an investigator, have you tried to identify her?
No, I haven't.
Is that something you plan to do?
I can try. I don't know who was in that courtroom.
Okay. Is that something you would typically do on a case like this?
I would definitely try to identify all witnesses, yes.
Mm-hmm. And the district attorney in the courtroom, Mr. Plummer, correct?
Yes,
He saw Mr. Ashby leave the courtroom, but didn't see anything that happened out in the hallway, correct?
correct.
So he wouldn't be able to differentiate if Mr. Ashby just came out there and was saying things at a distance, or if he made the approach that's kind of at dispute.
Correct.
And as far as you're aware, no other witnesses made any suggestion that Mr. Ashby tried to make any continued physical force once Mr. Steinberg was on the ground.
No,
There was only one statement from Mr. Buffington,
correct.
and that
I
was,
believe that was Mr. Hansen.
oh, Mr. Hansen.
Yes.
And Mr. Hansen was the one who didn't see that.
He didn't see Mr. Steinberg before.
The initial push.
Correct.
And so no, at the scene, there was no statement such as that, right?
Correct.
And it's undisputed that Mr. Ashby didn't make any additional physical attacks or anything like that
No,
after Mr. Steinberg was on the ground.
no.
But he tried to elbow him.
That's all I have. Thank you.
Thank you.
Eyeball.
Any redirect examination?
Defense counsel asked you about his client's account of what occurred. And did you have an opportunity to review the body-worn camera footage of the interview that he provided
Yes,
to Deputy Tucker? Did the defendant admit to getting up, to being in the courtroom beforehand,
yes, he did.
just as DA Plummer indicated?
Yes,
And then he got up and he went outside the court.
yes,
And did the defendant admit that he approached Mr. Steinberg's client
yes, he did.
and that he did so because he wanted to quote unquote see the child murderer?
Yes,
Were those his specific words?
they were.
He wanted to see the person that killed his nephew.
Correct.
And did he admit to saying those words, to calling that young man a child murderer as he's approaching?
He did.
And then was it as a result of the defendant's actions that Mr. Steinberg pushed him?
Based on witness statements, I would say yes.
I have nothing further here. Thank you.
All right, thank you. May this witness be excused?
Without that.
That's right.
Any objection? No. All right, thank you. You can go ahead and step down.
Thank you.
She made me really feel
Any
his
further
pain.
witnesses from the people?
when
Not
she
this
was
time, thank
talking
you.
about his hips.
All right. Any witnesses from the defense?
No, Your Honor.
Do the people wish to make any argument?
Reserved for rebuttal.
Any argument from the defense?
Your Honor, we just asked that.
No. You shut up for a second, sir. No, all this is a probable cause hearing. Did this person commit this crime? Not what is the defense of why, how, blah, blah, blah. Did this person commit this crime? This lawyer has no idea what a probable cause conference is for. It's fine.
That you consider the self-defense statements made here. Mr. Ashby does have a constitutional right to self-defense. We disagree that that shouldn't be considered at this stage, and that Mr. Ashby can be continued to held in custody, and this case can proceed no matter what self-defense evidence is put forth at this time.
Any rebuttal from the people?
Yes, Your Honor.
Buckle up. We're about to hear about Mr. Ashby.
It's very clear that the underlying case is a tragedy, and I just want to make it very clear to everybody that that's listening, to the defendant himself, that nothing about kind of what we're discussing today diminishes any of what they're going through. But at the same time, we have to address what occurred in this particular case, and we have to look at his behavior as a result of that. We've already talked about that we're really not here to parse out this self-defense claim. But I also recognize that you can't really divorce his self-defense claim and the underlying tragedy that we're addressing from the facts themselves. But even viewing all of that, even keeping that top of mind, there is no question here that the defendant approached the client, that Mr. Steinberg's client, and Mr. Steinberg in this case, that he did so purposefully, that he did so in what the witnesses described as a very provocative manner. He was clapping his hands loudly, and it is a result of him walking into their personal space, the aggressive manner that he was walking, the way that he was clapping his hands, and the things that he was saying. And that's important. And again, I don't want to get too far into the self-defense, but it is and is going to continue to be our theory here that this is a case of provocation. We don't disagree that Mr. Steinberg actually made physical contact first. He admits that, and all the other witnesses admit that. However, that is not all by itself license to then go as hands-on, to go and be violent and do violence, especially if the individual on the other side of that acted as a provocateur. And that's what occurred in this case. And it isn't just language. It isn't just words. That's what the case law says, and statute says, that words enough are insufficient to create a provoking scenario. But it wasn't just words. The defendant got up, he moved out of the courtroom and into the hallway, and then he moved into an area that Mr. Steinberg and his client were occupying away from the front door of the courtroom. He walked up to them, continued to say provocative things, continued to clap loudly, actually got into Mr. Steinberg's physical space. And it is a result of the defendant's actions that we believe was designed to create just this sort of physical altercation that ultimately led us to where we are today. And regardless of the victim's personal condition, and whether he had any underlying conditions at the time, the fact remains that he suffered serious bodily injury. And I'm sure that when we move on to discuss bond, we'll talk more about the struggles that he has had, because he wants me to communicate that as part of his VRA message. The fact remains the defendant attacked that man and caused serious bodily injury. He did so purposely, Your Honor. So he acted with the intent to cause bodily injury. He acted with the intent to provoke the victim into physical conduct. Both of those things occurred, and as a result, the victim suffered serious bodily injury. We would ask respectfully that you bind this case over and find probable cause to move forward.
All right, thank you.
I was wrong. It's coming. I thought it was right there. We're going to hear more about Mr. Ashley soon.
All right, the court will note that the purpose of a preliminary hearing is a screening device rather than a mini trial. At the preliminary hearing stage of the proceedings, the people are not required to lay out for full examination or full inspection all witnesses and evidence in a case. But pursuant to People v. Johnson, 618 Pacific 2nd, 262, a Colorado Supreme Court case from 1980, the people are tasked with establishing probable cause for each preliminary hearing eligible count. In this case, as previously mentioned, that is count 1. When the court is determining whether the people have satisfied that burden, the court must determine whether the evidence submitted is sufficient to induce a person of ordinary prudence and caution to a reasonable belief that the defendant committed the crimes charged. And when the court is making that determination, the court must view the evidence in the light most favorable to the prosecution at the preliminary hearing stage of the proceedings. To the extent that testimony or evidence conflicts at this stage, the court must draw all reasonable inferences in favor of the prosecution. And so the court views the evidence through that lens. The court will note that per the Colorado Supreme Court, probable cause is a low standard. That's People v. Fry, 92 Pacific 3rd, 970, a Colorado Supreme Court case from 2004. And as the court previously noted, while someone certainly does have a constitutional right to self-defense, and while that is certainly an issue at trial, the court is not in a position to determine the issue of self-defense at the preliminary hearing stage of the proceedings because affirmative defenses are simply not relevant to the issue of probable cause. I heard from 2 witnesses during this hearing. The court finds the testimony from both to be generally credible. The first was Deputy Brian Tucker. He's been with the Arapahoe County Sheriff's Office since 2014, and he's a court services deputy. He performs safety and security at the courthouse, and on December 8th, 2025, around the time of 1:30 p.m., he responded to an incident that occurred here at the courthouse at 7325 South Potomac Street in Centennial, Arapahoe County, Colorado. He was escorting an inmate to a different hearing when a clerk informed him about an incident that took place here on the 3rd floor. So he exited Division 306 and into the main hallway where he observed Mr. H. Michael Steinberg laying on his back to his left. He recognized Mr. Steinberg from prior work experience because Mr. Steinberg practices in this courthouse as a private defense attorney. And Deputy Tucker was also aware of his name from that previous experience as well. Mr. Steinberg appeared injured at the time, and ultimately Deputy Tucker also observed Mr. Ashby, who appeared to be animated in that location. Deputy Tucker noted a large amount of public present at the time and noted that Mr. Ashby was detained in order to remove him from the area and de-escalate the situation. Deputy Tucker did not make any presuppositions about what occurred. He moved outside of Division 302 with Mr. Ashby and seated Mr. Ashby on a bench. At that time, Mr. Ashby mentioned someone in a shirt and tie who was a witness and asked Deputy Tucker to speak to that witness. Another deputy remained with Mr. Ashby when Deputy Tucker went to find and interview that witness. And it was noted that there was another court case that ultimately precipitated all of this, that Mr. Steinberg was defense counsel for the defendant in that other case. And ultimately, the defendant in the other case was charged with a crime against Mr. Ashby's nephew. There were family members on both sides of the underlying case present in the area where the incident that gave rise to this case occurred. And while walking shortly after the incident, Deputy Tucker noted that he heard a female state that the attorney should be arrested. The female ultimately declined to provide written or verbal statements. He also noted that there was a person in a blue suit that was not affiliated with either family. Deputy Tucker spoke with that individual, and he stated that Mr. Ashby approached Mr. Steinberg aggressively.
About that female that we were talking about, all she said was, she said in a passing comment to one of the officers, the lawyer should be arrested. Now, he's a defense lawyer. Nobody knows why she said that. Nobody has any idea. He's a defense lawyer. He's a criminal defense lawyer. Chances are nobody in that courthouse likes him. I mean, if he was a criminal defense lawyer and she was a victim in a case, she would be happy he's on the floor. She would say things like, that lawyer should be arrested. So nobody knows if she meant that because he was pushing the mad guy. If I saw an aggressive person coming at someone and someone stand in the way and push them back, I would never in a million years say, oh, that person should be arrested. So nobody knows why she said that, and they didn't really get into it. So I don't know why the judge brought it up, but I think he's just going over everything that he heard. But I don't think during the trial anything's going to happen with that, with her.
Steinberg told Mr. Ashby to go back into the courtroom, that Mr. Steinberg was behaving in an aggressive manner towards Mr. Ashby, and that Mr. Steinberg was trying to create space between Mr. Ashby and his clients. At that point, Mr. Ashby took Mr. Steinberg to the ground. There were other witness statements that were collected and gathered from other individuals who were in the area. And based on the totality of the circumstances, law enforcement determined that Mr. Ashby was the initial aggressor. So Mr. Ashby was taken into custody. He made spontaneous utterances at some points around that time frame. And he was also provided with a Miranda advisement. He chose to provide statements thereafter. And Mr. Ashby stated that he approached Mr. Steinberg and his clients. Mr. Ashby admitted that he stated that he wanted to see the child killer or child murderer. And Mr. Ashby noted that Mr. Steinberg stepped in between Mr. Ashby and Mr. Steinberg's client, told Mr. Ashby to go back into the courtroom, and then pushed Mr. Ashby 3 times. Mr. Ashby demonstrated the pushes during the interview, and based on counsel's, reenactments, they appeared to be double open-hand pushes out from the person. The court will note that Mr. Ashby admitted that he took Mr. Steinberg to the ground, and when he said took to the ground, Deputy Tucker understood that to mean a physical takedown. On cross-examination, it was noted that Deputy Tucker's body-worn camera was turned on when he exited the courtroom. He observed Mr. Steinberg on the ground. He observed Mr. Ashby standing nearby. Mr. Ashby's family began speaking with Deputy Tucker, and Mr. Ashby made no attempts to resist or flee. The first witness Deputy Tucker contacted mentioned that Deputy Tucker mentioned she didn't appear to be involved with either family, and she was described throughout this hearing as the lady in brown or black. This individual stated that the attorney should be placed in handcuffs, and Deputy Tucker noted her opinion but did not form any conclusions based on it. It was noted that the time was approaching 1:30 p.m. and dockets in this courthouse start around that time, so it's possible this woman needed to be in the courtroom around that same time frame. And Mr. Ashby asked deputies to follow up with this woman. It's unknown exactly when and where deputies did so, or when they attempted to find her thereafter. The deputies did look for other witnesses and interviewed them around the same time frame. Deputy Tucker did not personally collect the witness statements, and he noted that the relationship between the witnesses and the involved parties is beyond his knowledge as he testifies today. He noted it's possible some of the individual witnesses were family of Mr. Steinberg's clients, and he noted that at least one of the witnesses was nevertheless independent. Regarding the underlying case, it's unknown to Deputy Tucker whether tensions were high at the time. It certainly sounds like they were. But based on statements that were made by the witnesses, it was noted that Mr. Steinberg was in the hallway speaking with his clients when Mr. Ashby was in the courtroom. Ashby exited the courtroom and stated, "I'm here to see the child killer," at which point Deputy Tucker considered that language to be provocative, as he noted. He noted it's not necessarily a threat of physical harm or an act of initial aggression, but a person would expect a reaction when someone uses language along those lines. And after the initial words were exchanged, but before the physical incidents, Mr. Ashby told deputies that Mr. Steinberg pushed him 3 times before he ultimately went hands-on with Mr. Steinberg and took him down. Per Mr. Steinberg, he got in between his client and Mr. Ashby, but not necessarily closer to Mr. Ashby when he made that move. With respect to physical force, Mr. Ashby stated over and over that he was shoved 3 times before taking any physical action, and Mr. Ashby again did describe those shoves. Mr. Steinberg admitted that he pushed Mr. Ashby first to protect his client, and with respect to Mr. Steinberg, it was noted that he is significantly taller and heavier than Mr. Ashby. The NCIC reports for each of these 2 individuals were discussed, and it was noted that per Mr. Ashby's DMV dossier, he is 5'10", 180 pounds, whereas Mr. Steinberg is 6'1", 245 pounds. Regarding the force used by Mr. Ashby, it was repeatedly referred to by witnesses as a body slam or a takedown. Mr. Ashby stated that he swooped Mr. Steinberg's legs, and witnesses noted that Mr. Ashby was still heated after the takedown. Mr. Ashby stated something along the lines of, "You caused this," after the takedown occurred. And once Mr. Steinberg was on the ground, Mr. Ashby did not continue to assault him thereafter. After Mr. Steinberg was on the ground, it was noted that he appeared to be in significant pain. Mr. Steinberg had communicated to Deputy Tucker on a previous occasion that he had a pre-existing back injury. The details of that injury are unknown, and it's unknown whether that injury was pre-existing or whether it was caused, the injury that was discussed during the testimony, whether it pre-existed this incident, whether it was caused by this incident, or whether it was made worse by this incident, or none of the above. One witness stated that Mr. Steinberg didn't push Mr. Ashby first, did not, but this contradicts Mr. Steinberg's own admission that he did in fact push Mr. Ashby first. And regarding a witness in a blue shirt with a tie, that individual stated that both Mr. Steinberg and Mr. Ashby were both aggressive during the incident. When that individual was asked why Mr. Steinberg pushed Mr. Ashby, he said something along the lines of to create space, although this may have been in response to a leading question from Deputy Tucker. The interview was captured on body-worn camera, and on redirect examination of Deputy Tucker, it was noted that the relative age of the parties is significantly different as well. Mr. Steinberg is 69 and a half years old, whereas Mr. Ashby is approximately half his age at 36. Generally, it was noted that the witnesses that were spoken to were consistent regarding the sequence of events. The court also heard from investigator Jamie Wright with the Arapahoe County Sheriff's Office. She's been a law enforcement officer for approximately 25 years. And here she read all of the reports, watched the body-worn camera footage, and reviewed the witness statements. She noted that Mr. Steinberg, with respect to his injuries, she did receive a medical record report for Mr. Steinberg. The report indicated multiple pelvic fractures and several surgeries required as a result of those fractures. The serious bodily injury form was provided to law enforcement, and that form listed multiple fractures, including spinal fractures, which do constitute serious bodily injury according to the individual who filled out the form. An individual by the name of Glenn Hansen was interviewed. He was present and witnessed the incident. He had a traffic case here in the courthouse that day. He did not become involved in he was not involved in the underlying case that was referenced previously. And he stated that he was standing in the hallway when he saw a gentleman walking briskly, clapping his hands loudly like he was on a mission. He said something, the gentleman who was clapping his hands, or saw something and beelined toward it. Mr. Hansen described it as an airborne shuffle. He noted a quick pace. The person was not running, not walking, but moving with a purpose. Mr. Hansen couldn't see the other person that the man was walking toward, but Mr. Hansen heard words exchanged. Mr. Hansen then observed the man who was walking toward the other man pick that man up and slam him on the ground. Mr. Hansen was watching the entire time that this occurred and believed that Mr. Ashby made the first physical contact. After the attorney was on the ground, according to Mr. Hansen, Mr. Ashby was about to drive an elbow into Mr. Steinberg. And so Mr. Hansen and another individual physically pulled Mr. Ashby away. And ultimately, Mr. Ashby was identified at the defense counsel table as the individual in the orange jumpsuit in the courtroom today. There was an individual by the name of David Buffington who was also interviewed. He was wearing a white shirt with a blue tie on the date of the incident. He was not affiliated with either side of the underlying case, but noted that he was close to the incident which gave rise to this case when it occurred. He said he saw a male in a shirt that said "Justice for Someone." This male was clapping his hands loudly, and at that point, the male approached a Latino man who was identified as the defendant in the underlying case. The male with the shirt, the Justice for shirt, was yelling something along the lines of "Let me see the child murderer." At which point, Mr. Steinberg stepped in between his client and Mr. Ashby. Mr. Ashby picked Mr. Steinberg up and slammed him onto the ground, according to Mr. Buffington. And Mr. Buffington saw the attorney shove Mr. Ashby before Mr. Ashby slammed him to the ground. The attorney pushed Mr. Ashby because, in the opinion of Mr. Buffington, Mr. Ashby was very aggressive toward the Latino man who Mr. Steinberg stepped in front of. Cole Plummer was identified as the district attorney handling the underlying case that Mr. Steinberg was involved in. And it was noted that Mr. Plummer was in the courtroom at the time of the incident preparing for a hearing in that underlying case. At the time, Mr. Ashby was in that same courtroom, but he got up with a purpose, as Mr. Plummer put it, and exited the room. And ultimately, after reviewing the entirety of the case, Investigator Wright noted that the determination was made that Mr. Ashby approached Mr. Steinberg in an aggressive manner. All of the witnesses seemed to agree with that piece of it, at least. On cross-examination regarding the SBI form, it was noted that Investigator Wright did not speak directly with the doctors, and she has no personal knowledge of the injuries that Mr. Steinberg sustained. Regarding several of the witnesses that were contacted stated that Mr. Steinberg made the first physical contact. Mr. Hansen was one of the witnesses who did not state that, but he did say that from where he was standing, he could not see Mr. Steinberg at the outset of the incident. Mr. Buffington stated that Mr. Steinberg was also aggressive and that Mr. Steinberg tried to step between Mr. Ashby and Mr. Steinberg's client. And again, Mr. Steinberg admitted that he had stepped between his client and Mr. Ashby prior to the physical confrontation. It was possible that this reduced the physical space between Mr. Steinberg and Mr. Ashby, but not entirely clear based on the statements. With respect to the lady described as the lady in black or brown, she made that initial statement about the lawyer should be in handcuffs, but no formal statement, and she refused to provide a formal statement or her identification in connection with this case. Ultimately, it was noted that DA Plummer did not see what happened in the hallway, and on redirect examination with respect to Mr. Ashby's statements, again, it was reiterated that he admitted to being in the courtroom before the incident occurred. He admitted to exiting the courtroom, and he admitted to approaching Mr. Steinberg's client to, quote, see the child killer or murderer. So that's the evidence that the court has to make a decision in this case. Again, the court will note that count 1 is eligible for preliminary hearing. Count 1 is assault in the second degree, and it requires that the people prove first that the incident occurred on December 8th, 2025. That was the date of the offense that the court heard during this hearing. It went mainly unchallenged, and so with respect to that date, the court will find adequate probable cause that the incident occurred on December 8th, 2025. The next piece of this is whether Mr. Ashby is the appropriate individual identified as the suspect. The court will note that Mr. Ashby was positively identified in the courtroom as the individual in the orange jumpsuit by both of the witnesses. A number of individuals identified him as the other individual identified in the physical altercation, to include himself. He admitted that he was involved and admitted to his version of the event.
Okay, we get it. Hurry up and get to the next part.
Events here. So as far as identification goes, the court will find adequate probable cause of the same. The next piece of this is whether Mr. Ashby had the specific intent or conscious objective to cause bodily injury to another person. Generally speaking, all of the witnesses agree that Mr. Ashby took Mr. Steinberg down in some form or another. It was referred to as a takedown on several occasions. Mr. Ashby referred to sweeping Mr. Steinberg's legs, but ultimately, regardless of whether it was a tackle, a takedown, or sweeping someone's legs out, generally when you approach an individual and take that person down to the ground in a forceful manner, you do so generally with the conscious objective to cause some bodily injury to that person in the absence of context that would provide otherwise. And in this case, the court doesn't recognize any such context based on the testimony. So with respect to probable cause of the specific intent to cause bodily injury to another person, the court will find adequate probable cause based on Mr. Ashby's versions of the events, frankly, that the actions that he undertook would be designed to do the same. The next piece of this is whether he did in fact cause serious bodily injury to Mr. Steinberg. And the evidence that the court has is a serious bodily injury form from medical providers who ultimately found that Mr. Steinberg sustained fractures, specifically a spinal fracture. Ultimately, the medical provider did find that the injuries he sustained constitute serious bodily injury. It was also mentioned that Mr. Steinberg will require surgery in reference to the spinal fracture that was discussed. And so with respect to the definition of serious bodily injury pursuant to CRS 18-1901, that definition specifically includes fractures. And those are what the hospital found here, or the medical providers in any event. So the court will find adequate probable cause as to causing serious bodily injury as well, and the court will bind over counts 1 and 2 to the district court. I will note that there are a lot of issues, it's obvious during this hearing, relating to the issue of the affirmative defense of self. And ultimately, those issues are ripe for a jury trial. They are issues that a jury certainly will consider, assuming that Mr. Ashby presents a modicum of evidence in support of those. They are not issues that the court can consider today in making a determination as to probable cause. So things along the lines of Mr. Ashby reasonably believing that he was in the path of imminent harm, whether his response was proportional to any aggression from Mr. Steinberg, whether he was provoked, are all issues that are relevant at trial, but not at this hearing today. So I will invite the parties to ask any questions or make any requests for clarification. Anything from the people?
No, thank you.
Anything from the defense?
Nothing from the defense.
All right, this case will be bound over to the district court and set for arraignments. If I could please get a good date for arraignment in Division 206.
Council, the court can offer February 13th or the
Happy
next available
Valentine's
one,
Day.
March 20th at 1:30 p.m. in Division 206.
I'm so sorry. I won't pick on him. No way.
I think it's up February 13th.
That was at 9 a.m.
On February 13th, 1:30 PM, Division 206.
How does that work for the people?
Should I put this on my calendar to get or not get? Because they talk a lot.
I can accept that. All right, so that was February 13th, 1:30 PM and 206. All right. Apart from that, any other issues we need to address from the people?
Not from the people.
From the defense?
Yeah, that's a good one.
Okay. Are the people VRA compliant to address bond?
Yeah.
All right, I believe this is the third time we're addressing bond inside of 2 months. Is there a change of circumstances of some kind?
Your Honor, we believe that the testimony we heard today was not previously available to the court. None of this was in the probable cause statement. So we do believe that the additional information we learned today is a significant change of circumstances.
All right, argument as to bond from the defense, please.
As the court mentioned here, there are several aspects of self-defense, and I know that they're not relevant for preliminary hearing in this court's view and
Do you though?
under
Do you
case
know
law
that?
from the Colorado Supreme Court, but we certainly think it's relevant here. And in this situation, we have witnesses that are suggesting that the lawyer should be placed in handcuffs. We have witnesses suggesting that the lawyer was aggressive. I think that kind of looking at specifically kind of the witnesses that were neutral here, not involved, the lady in black or brown made that initial statement that the police need to place the attorney in handcuffs. Obviously, it would have been ideal if she would have spoken more, but we do have that statement. Looking at the events unfolding, there were the initial words, and we know that individuals describe Mr. Ashby as an aggressor or as provocative, but he saying words while considered provocative to a layperson, and this is what Deputy Tuck and I were discussing, does not necessarily mean that that's provocation in the sense of self-defense and the ultimate result at trial. So I understand why all of the witnesses here would say that Mr. Ashby was the one provoking. He was the aggressor. He was the agitator, because I think you look at him going out in the court, coming out in the hallway and saying those things, that's a pretty clear takeaway. I think that most people would agree with that, but it doesn't mean that that's provocation for self-defense, especially if he did keep his distance like he told police he did, that he and that Mr. Steinberg came up to him to cut in that space. And we do have information to suggest that that physical distance was cut by Mr. Steinberg. He didn't kind of get his client back. He kind of came forward. I think that it gets difficult, but I think that that's a reason to look at lowering the bond here, because there's an aspect of what exactly happened. I think what's not in dispute is the use of physical force. Mr. Ashby was not the first one to use physical force. And that's certainly an important factor when it comes to the safety of the community, that yes, he used physical force, but not first. And we look at we discussed the size and weight. I understand that that is kind of offset by the age. But this takedown he used, there's no evidence that it was of extreme nature or extremely forceful. It was just scooping the feet. It was certainly tragic that it resulted in the injuries it did. But the fact that it appears that Mr. Steinberg was particularly susceptible to those injuries, I understand that kind of take someone as you find them.
So if they're susceptible to that, then you should really depend on that more, right? So what this attorney is saying is If he's susceptible, we should pay attention to that. Okay, fine. We will.
Under the law. But when it comes to the safety of others, it's certainly relevant that the force used, and when it comes to reasonableness, whether the force was reasonable, the force used in response to the shoving here, the fact that it may not have caused injuries, there was no weapon, there was no knife, there was no gun, it was simply scooping the feet in a way that it would appear that if someone didn't have pre-existing injuries, wouldn't cause that type of serious bodily injury. And I guess the overall evidence is what's not disputed is Mr. Ashby didn't make any further physical contact while on the ground. The overwhelming evidence is that he didn't attempt to. The injuries here that happened are extremely unfortunate. I think that that's clear. But this happened in a heightened state that in an interaction where both sides were being aggressive, where Mr. Ashby didn't initiate physical contact, that doesn't translate into him being a danger to the community. I know we're about to hear about the seriousness of Mr. Steinberg's injuries from the prosecution here, but that's not particularly.
That's not what we're going to hear. Maybe we might hear it, but that's not the main point that the prosecutor is about to go through. Don't worry.
Relevant when it comes to whether or not Mr. Ashby is safe in the community. I can also tell you, and some of this is, the court has already heard that Mr. Ashby has been working at UPS for 3 years. He was able to hold a job, be a productive member of the community. He's obviously been in custody sometime now, but he's hopeful that he could resume that or some type of work. He's upset. His brother's son recently passed away, as we heard about in the underlying case. But Mr. Ashby has a son of his own that he wants to be there for. He unfortunately lost a daughter who was a newborn back in 2016, and he wants to be there for his son any way he can be. He is here to present his defense. I think that was clear from everyone we heard from today. He's adamant about what happened here, and it's not a situation where it's someone who thinks there should be concerns about him not appearing in court. He has the support of his family who are in the courtroom today. It's simply not the type of case where a $75,000 bond is appropriate. It was extremely aggravated kind of on all sides, and Mr. Ashby's use of force was never meant to have this type of injury. It's extremely unfortunate, but it shouldn't go into a determination of the safety of the community. For that reason, I don't think it would be unheard of to ask for a personal recognizance bond in this situation, but I do believe a $10,000 cash surety property bond is appropriate.
No, it's not.
Kind of given everything we just heard. So I would ask the court to impose that $10,000 cash surety property bond.
All right, thank you. People's position in VRA record, please.
Here we go.
The people vigorously oppose any sort of reduction. The bond is more than appropriate as set, and let me explain to you why. As I said previously, and as I'll say again, and I'm sure I'll say it later on as well. Nothing that I am going to say about this situation from here to the end of it is meant to diminish the terrible tragedy that this family has been through, continues to go through. I'm sure the court is aware of the very unfortunate timing of today and the fact that that case was resolved in part right before we started all this. And all that is terrible. I've tried those cases. I've not lost a child myself, but I have been there working with families that are in this similar situation, and it's terrible. At the same time, we just can't have the behavior that we had in this case. And When I really dug into this defendant, as I think you'll see here in a moment, what jumps off the page is that something like this was bound to happen and probably has happened in the past. And I'll get back into that here in just a moment when we get back and we talk about him. But I want to take just a moment to talk about the facts since defense counsel did. Look, I recognize, and I said this at the outset as well, I recognize their position here. Your Honor will note that we only addressed the quote unquote unbiased witnesses here. We only discussed the witnesses that were not part of either side of that of the underlying case, including the victim himself, which you could, I guess, say had a dog in that fight since he was the defense attorney on one side of it. And so even if we discount all the people that had some stake in the underlying case, what we still have are two people. The two people that decided to stay on scene and cooperate, that made it very clear who the aggressor was. The aggressor was this man, right? The fact of the matter is we don't have to be here. None of this had to happen. These were deliberate choices made by the defendant. He deliberately decided to get up to approach Mr. Steinberg and his client. He had no business doing so, and there was really nothing good that was going to come of any of that. He just had to inject himself into that circumstance. He had to see for himself the person that killed his nephew. For what reason, I have no idea, and what he thought was going to come out of that other than some sort of conflict, I can't possibly understand. Here's what I can understand. This behavior is not out of character for this individual. And like I said, something like this was bound to happen because here's the criminal history that we're dealing with here, and here's why he is absolutely a danger to the community. He has no prior felonies, I'll give him that, but he does have a very violent history and a history that I'm even more concerned about of completely ignoring court orders and doing whatever it is that he pleases. Your Honor, he has been arrested 6 times for assault. 6 times. 3 of those arrests were for second-degree assault involving serious bodily injury. Now, only 2 of those arrests ultimately resulted in convictions. Most of them are domestic violence-related assaults, which we'll talk about here in a moment. And the convictions themselves resulted in misdemeanor assault convictions, but he has a history of assaultive behavior. He has a history of assaultive behavior specifically as it relates to intimate partners, which I think speaks very loudly to the way that he reacts and responds when things don't go his way. And then what I think is truly remarkable and particularly concerning is that he has 9 arrests for violation of protection order. 9. I'm not sure in 15 years of doing this work, I've ever seen anybody with that many VPO arrests. 6 convictions. He is a domestic violence habitual offender. And so when you add all that up together, what we have seen repeatedly is an individual who cannot handle things well when things don't go his way. And when, in those circumstances, he acts violently, he harms people, and there is nothing that anybody can do to stop him or to change his mind. And he has no concern over about orders of the court or just general decorum. And when you take all that and you then process what we saw here, all of this makes complete sense. Again, he went through something horrible, something he and the rest of his family never should have. They didn't deserve to. And truly, my heart goes out to them. I don't mean to diminish that in any way. However, the question comes down to how are you going to respond to that? And what he responded to that by picking a fight, unquestionably. He did it in a courtroom, in a courthouse, where he knew there was going to be law enforcement all over the place. And quite frankly, we all now know in retrospect there aren't cameras in the courthouse. But I can't imagine that he knew that beforehand, and none of that made any difference to him. And if he's willing to behave like this in a court of law, and by the way, clearly this is, this is somebody who is familiar with the judicial process, who has been through the judicial process many times before. And he recognizes that in these terrible situations, our society has come up with a process to deal with this civilly. He knows that. He's been through that process. And yet he decided to take things into his own hands, knowing full well that he could end up right here because he's been here before. And so he was in control then, and he chose to lose control. He's done it so many times before. And when you look at that sort of history and you take into account the behavior that we've seen from him over and over again, I cannot see how this court could be satisfied that if he's out in the community and things don't go his way again and something upsets him, that he's not going to behave like he has so many times before and like he did here, brazenly and with violence, without any regard for whomever happens to be on the other side of his anger. And in this case, it was a 69-year-old man, nearly a 70-year-old man, who may never walk again. The defendant is lucky, Your Honor, that Mr. Steinberg wasn't 6 months older, because if he was, he would be considered an at-risk victim. The defendant would be facing an F3 mandatory DOC sentence, crime of violence. He'd be looking at 10 to 32 years in the Department of Correction. And that's just sheer dumb luck. That's just because of the timing of all this. It had nothing to do with the defendant and his decision not to attack somebody who's over twice his age. And if he's going to attack somebody in that circumstance who was doing nothing other than doing his job, who is a part of the process that our society has put in place to try to deal with terrible things like this twice his age without violence, then we cannot trust him to act any better when no one's looking. And so I have great concerns about the safety of the community. I have great concerns about his propensity to reoffend, because he has before. And given the severity of this case, given the severity of the injuries that he's caused, the bond is appropriately set, Your Honor. And Mr. Steinberg did want me to pass along just how very deeply he is affected by all of this. It is not clear that he's going to recover. If he does recover, it's unlikely that he'll be back to what he was before. It's not clear he's going to be able to work again. That's a very important part of his identity. And he's having a really difficult time. And I know that the defendant is too, and I know his family is too, and we're not here to compare tragedies. The point here is that this didn't have to happen. It did because the defendant flew off the handle, and I'm not sure that we can trust him not to do it again.
All right, thank you. Will the courts consider the statements of counsel, the court's own file, the pretrial bond report, and the position of the victim? The court will note that at the previous hearing, when the court addressed the issue of bond, Mr. Steinberg's son appeared and made an impassioned record at that particular hearing. There's no sugarcoating this case. It's tragic on both sides of the aisle, and I don't think there's any doubt about that. Ultimately, with respect to the way that this happened, I don't know much about the misdemeanor case. I know that's ultimately, in that case, Mr. Ashby lost a nephew. And it appears, based on my understanding of the way the case resolved today, that the defendant in that case was culpable for that loss. I would be surprised if Mr. Ashby wasn't very angry. I'd be surprised if he wasn't furious sitting in that courtroom that day. And it's not for me necessarily to speculate as to what was going through his head on that date and the emotions he was feeling. The same is true of the rest of the family. Losing a child like that is awful. And so the court certainly understands why Mr. Ashby was angry that day. Frankly, Mr. Ashby exited the courtroom and he made some statements that sound like protected speech. If he referred to this individual as a child killer and the person did kill a child, I think he's got the ability to make such commentary. The line that the court sees between that and what ultimately occurred is At some point, the words end and the accosting the defendant in the other case begins. And this is a bit of a circular case in the sense that ultimately Mr. Ashby argues the force he used was reasonable because he was pushed 3 times by Mr. Steinberg. The people argue that Mr. Steinberg's pushes were reasonable, essentially, because Mr. Ashby accosted his clients and he suspected that some physical altercation was going to ensue. Ultimately, that's not for this case to for this court to parse through at this stage. I do think, although an affirmative defense is not relevant to the issues at preliminary hearing, it is relevant to the issue of bond because one of the issues the court must consider is the likelihood of conviction. Here, I don't know it's every time that you tackle someone you expect for injuries of this degree to occur. That being said, Mr. Steinberg is old. He is a very large in stature, and certainly it's not beyond the realm of possibilities that taking someone down, such as Mr. Steinberg, could result in the kind of life-altering, debilitating injuries that have apparently occurred. The courts, if this were a situation where it were a one-off, if Mr. Ashby was processing the emotions of dealing with the loss of his nephew, he lost his cool, lost his composure, and this resulted. Ultimately, the court would view this a little bit differently. The court does point to the bond report, which rates Mr. Ashby at a -3 high risk. It notes extensive criminal history. None of it consists of felony convictions, but there are a lot of misdemeanor convictions. The total of 19 convictions in his past. 6 of those conservatively are violation of court orders. There appear to be potentially another 2 if we consider the violation of court conditions and violation of restraining order convictions to be the same. And so if the court were satisfied that ultimately the protection order in this case would provide the victim safety that the court needs to ensure occurs, then I would view this situation a little bit differently. But certainly based on the violation of protection order history, the court's not comfortable that I can count on Mr. Ashby to comply with the court order in this case. There are also 4 prior convictions for assault. We heard a little bit more about the context of those convictions. The most recent of those convictions did occur within the last few years, and it looks like probation has been revoked once on that case already. It doesn't appear that the violence, the assault piece of this is a one-off, and it instead appears that it's somewhat consistent with some of these prior convictions. I'm sure that this occurred in a completely different context than some of the other, specifically the domestic violence-related assault convictions. But ultimately, at bottom, this case is retaliatory in nature. It's impulsive. Mr. Ashby was angry. He had every right to be. But ultimately, that anger was not contained on the date of the offense in this case. And whether it was a desire to confront the defendants in the other case or to retaliate against him or some combination of those things, it's certainly possible that situation reoccurs in the near future in the absence of something to stop it from doing so. The court will note that bond was set originally above the guideline amount for this particular offense. The court acknowledges the self-defense issues in this case. In this court's view, based on the totality of the circumstances, and albeit I did preclude a lot of information related to the affirmative defense at preliminary hearing, it doesn't seem like a reasonable use of force in defense of self, and ultimately doesn't seem like a case where the jury would find the same. And I'm certainly not rendering that determination today, but I'm just considering it in the context of whether a bond adjustment is appropriate. Ultimately,
Listen to this, Judge. This guy is screwed. I don't know if he's going to go in front of a jury, if he's going to do a bench trial, or if he's going to plead out. But he's screwed if he does a bench trial.
given the demonstrated failure to comply with court orders in the past, the multiple prior assault convictions, the extent of the injuries in this case, and under the totality of the circumstances, while the court certainly understands why Mr. Ashby was angry, the court cannot justify a bond reduction based on the record that's been made today. So the court will decline to address or to adjust bond. The court will maintain bond in the amount of $75,000 cash or surety with all prior terms and conditions of bond. That's no leaving the state without prior permission and a waiver of extradition. We've got our next appearance dates for arraignment on February 13th at 1:30 p.m. in Division 206. Apart from that, are there any other issues from the people this afternoon? Nothing. Anything else from the defense? Nothing from the defense. All right. Have a good day, Mr. Ashby.
I don't think that bond is high enough. I just don't. 75,000? No. 75,000 for, the third aggressive assaultive case, maybe. 75,000 maybe for the fourth. But this, how many does he have? I mean, they said that he had, well, I know they said that he had 9 domestic violence episodes with 6 convictions. So he was arrested 9 times, got 6. But the other one was, I don't remember what they said. I wish I remembered. He had other assaultive cases that were not domestic violence that he had. That was the domestic violence, was the 6. Before that, I think you're right. I think they did say 6 and he had 3 convictions. Those were different. Those were not the domestic violence. I think they were protection from abuse violations or something like that. So, yeah, I mean, gun to my head, I would have swore he had a felony in his record because I listened to this whole thing. I had watched this whole thing before I showed it to you guys because I couldn't pull myself away. I firmly thought he had some felonies, the way that the prosecutor was talking. So now my title and my thumbnail are all just big fat freaking lies. But it's alright, only 100 people saw it. Right? I'm not a bait and switch artist. I usually say exactly what you're going to see. I do. But anyway, guys, if you're here for a court, it's over now. Thank you so much for coming out. I really appreciate it. I had a story to tell you. Oh, no, never mind. Guys, thank you so much for coming out. I appreciate that you came out tonight. I know it's a weird time. I know it's in the middle of the night for some of us. We're up in the middle of the night. And we'll be up again in 6 hours doing it all over again. I have some child custody cases. 3 tomorrow. They're not terribly long. I'm going to find more. But I'm starting with 3. The middle one is very short, and it's one that we all need to see. The middle one is in the morning is just a case that we all need to see every once in a while. So that's for a couple hours from now. That's 6 more hours, 7 more hours. Thanks for coming out, guys. Please behave. Try not to tackle any 69-and-a-half-year-olds. Just don't tackle them. Yeah? Get back in your car. Jean, get back in your car. It was nice to see some old faces tonight. Bill, go home. It's late. You can still make it, though. Just go home, Bill. Bye, guys. Have a great night. Thank you. Time to sing really, really loudly.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.